Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
Hi, I'm one of your hosts, Elizabeth Morris, Senior Director of IP and Product at Everpure Incorporated. In my role, I manage the patent portfolio at Everpure. Let's go ahead and dive right in.
Non-practicing entities have a big impact on the U.S. economy. It's hard to put numbers around it, given some of the secrecy, but a 2022 article in Harvard Business Review estimated the yearly out-of-pocket costs to companies fighting patent trolls to be $29 billion. That's money that otherwise could be used for R&D. And no industry is exempt, as semiconductor industry folks would attest with some of the odd patents listed in cease and desist letters on their desks. Challenging these asserted patents is one of the few ways to stop NPEs, otherwise the NPEs will find more licensing targets. But the non-practicing entity model forces a decision. Is it worth fighting this patent when I can settle for less than the cost to fight it? And why should my company pay these costs when my competitor is the one that benefits? That's where unified patents comes in. We're joined on this episode by Sasha Sokhis to learn about how unified patents deters invalid or unsubstantiated patent assertions. Welcome, Sasha. To start today's episode, would you please give a quick introduction to yourself?
Absolutely. Thanks, Nathaniel. And it's great to be here. I'm excited. This is my first podcast, so thanks for having me. I'm Sasha Sokhis. I'm a Senior Vice President of Client Relations and Business Development at Unified Patents. I have been in the IP space for over a decade. I started at a boutique investment bank called Blackstone IP, focused on advisory, valuation, transactions, really trying to unlock the value of patents for operating companies, either to sell assets or to identify acquisition targets that they might want to acquire for cross-licensing or litigation defense strategy. Then moved on to a bigger investment bank called Houlihan Lokey, doing the same things, advisory, transaction, valuation type of work, but now leveraging the bigger organization. So, for example, the bankruptcy group or the capital markets. In a bankruptcy, oftentimes there might be a patent portfolio that's quite valuable. Identify those assets and separate them, create different values for our company. And then in 2020, I moved on to Unified Patents, which has been a great stay. I've worked with all of our corporate clients, our corporate members, as well as bringing on new members in all of our different technology areas. And it's interesting knowing my background of some of the patent transactions that we've done that kind of make full cycle. They might go in the hands of NPEs that are now being asserted against our corporate operating companies, and being able to understand both sides of those transactions has been very helpful. So happy to talk about the unified model today.
Sasha, we're so happy to have you here. I think Unified Patents has a really unique position that they're offering companies, and so really looking forward to digging in on that today. For our listeners who might be unfamiliar, what is Unified Patents and what motivated the creation of the organization originally?
Sure. At its core, Unified Patents is an offensive organization designed to solve that massive imbalance Nathaniel mentioned between the NPEs, the non-practicing entities, and operating companies. So NPEs are patent trolls. These are entities that don't actually make products, but they acquire patents solely in order to assert them against companies that do. So therefore, operating companies don't have that same ability to countersue or cross-license as they would in competitor litigation. And that traditional NPE life cycle is to purchase a patent, to assert it, to force a settlement, get more money, buy more patents, and continue on. And oftentimes, as Nathaniel said, the ask for settlement is just below the cost of litigation. And as a result, about 98% of operating companies just settle and pay and move on. But that really fuels that fire or that monetary resource for patent trolls to acquire more patents and then come after and assert more of them. And really those NPE litigation statistics are pretty staggering. So about 88% of high-tech patent litigation is driven by NPEs. And why is, again, there's not much recourse that operating companies can have except for challenges. And those challenges can be very expensive. So, we're talking about a low bar of 200,000 to top patent challenge and so forth. And then, of course, litigation is millions and might take years. And that was really the impetus of Unified. Our founder, Kevin Jekyll, was into it, had that cycle of NPE litigation, and really had the idea of creating unified patents to level the playing field and break the cycle and to arm corporate members in order to really fight back and deter further NPE assertions by using post-grant challenges. And those post-grant challenges, they're filings within the USPTO that are meant to attack the validity of an issued patent, and they are open to third-party filers like Unified Patents. And there's two challenge options, essentially. The IPR, the Inter Partes Review, which was created by the American Invents Act, which is around the time of launch of Unified, and then the established reexam challenge too, their ex parte reexamination. And Unified started back in 2012 by actually doing both reexams, IPRs, and we have moved to exclusively filing reexaminations in about 2023. And we saw a great level of success in pre-filing licenses. There's some companies are able to motion to stay in light of reexaminations, increase budgets for reexamination challenges versus IPR. So it's been a great shift for our business, and actually has proved to be quite valuable given the recent outlook on IPRs, which I can touch on more later.
So I can see where Unified Patents fits in with a large company that's a big target for patent trolls or NPEs, but how can a company with a smaller budget engage with Unified Patents to try to strengthen their defensive posture?
Yeah, absolutely. So Unified is meant to arm all companies to protect against NPE assertions. And instead of bearing that full cost of a challenge that I mentioned, very expensive, members are joining zones based on the technologies that are relevant to their company. And we're able to pool the resources between those companies. So smaller budget companies get that same deterrence shield as the bigger players within the zones and the general organization. So by joining a zone, your annual subscription fees are allocated to challenges of patents that are in that specific tech area. For example, financial institutions join transaction zones, and then maybe some of our big companies that are multidimensional might join as enterprise members, meaning all of the zones are covered within their membership. And we structured it to be a highly accessible membership. So membership is tiered by company revenue. Bigger companies are paying more, smaller companies are paying less. And we have members all over the world. We also have, for the really small companies, the startups, we have a startup program, and that we just modified it. But any company that makes less than 35 million in revenue can actually get the full protection of Unified Patents for $395 a year. So it used to be free. Now we've kind of modified it to be a bit more targeted for a specific revenue. But these startup companies are included in all of the Unified licenses, and they have access to the analytics platform, other member resources. They have access to the team to help them understand these NPE litigations, referrals to law firms, and things like that. So we really want to support and empower all these smaller companies with little resource to fight NPEs that are supported by the bigger companies. And oftentimes those smaller companies grow beyond that 35 million threshold and join as full members as well. So we support that cycle from the start.
That's really clever. I was just going to ask you, like, what's the benefit to Unified to give these small but I can see how, then it's good for the world. And then it's also, if they grow into something bigger, they already know you and understand your value. So getting them early makes sense. Can you talk specifically about your SEP and NPE zones and how they help companies deal with patent risk?
Yeah, absolutely. So the traditional Unified team membership is broken up NPE and SCP. So I'll touch on NPE first. There are about 12 zones ranging from our first zones that were created, cloud and content, to some of the newest ones like blockchain, medtech, and of course, US AI. We're constantly evolving our zones as technology areas become targets of NPEs. And I mentioned those subscription fees, they're allocated towards specific zones. There might be licenses that license to only the specific zone members, and we challenge the patents held by NPEs related to those technology areas. Now, standard essentials, SEP zones, those are a whole different beast. These zones are meant to deter unsubstantiated SEP demands and support good faith FRAN licensing negotiations, so fair, reasonable, and non-discriminatory negotiations. We try to improve those negotiations by providing transparency through our tools, and our tools are covering essentiality, validity, and improving licensing positions for negotiation. So it's very important in standard essential practice for a company to be considered a willing licensor, which means they have to come to the table for discussions. Oftentimes, NPE, if you get a cease and desist kind of letter assertion, you can kind of ignore them maybe until it becomes a bigger threat. With standard essential negotiations, you do have to come to the table as a willing licensor. And that requires to have some tools in your bag to be able to negotiate. And oftentimes, these are very big money licenses in the Wi-Fi space, in the video codec space. So Unified has various tools that we've created, and Unified loves acronyms. So the first acronym is OPAL, which is a landscape for each individual zone. Right now, we have the video codec zone, the Wi-Fi zone, and the 3GPP zone. And these, again, evolve as technologies do. So video codecs started focusing on HEVC back in 2019 and evolved into including VVC and now more of the streaming discussions. So Opal provides a landscape for each zone. Open is a repository of all of the standard submissions. So for example, the IEEE submissions for the Wi-Fi zone. And then we have Oval, which is the independent economic reports. So each zone has an independent economic report. Reports evolve as the technology does, and this better arms our members for negotiations. We also have a resource on our team, Unified Consulting, so someone that can help in these negotiations and really specific outlook on SEP zones for each member as well, and this could be done under privilege. So you can imagine this is a lot of work to maintain. Just this week, I think there's been talks we've been assessing 2 new pools and a new SEP litigation that is these are global litigations. And the fourth component I have to mention here in the SEP zones is also global challenges. So we are filing the challenges that we mentioned in the US, as well as challenging family members of those patents in Asia, as well as Europe. There's also just one new aspect we've created that falls between NPE and SCP. And again, the hot topic of AI, we have created a generative AI landscape, Opal. And this is meant to map the fast growing patent landscape around generative AI to help companies spot litigation risk before it happens. It does show a sharp increase in AI filings since 2017, which is probably not surprising, led by major tech companies. So it's signaling that Gen AI will be a heavily patented area. And then some of the data shows 10% of the recent transactions of patents to NPEs were also involving AI patents. So may signal that there's potential NPE risk related to the AI space, hence as to why we actually launched that zone, because everybody's a little bit scared of the unknown in that tech area.
Switching from the zones, I'd like to talk about another public-facing aspect of your organization, and that is the invalidity contests. And I'm curious how they work.
So we have Patrol, again, more acronyms, but this is our crowdsourcing of prior art. We post patents out there and put a bounty on them, ranging from $1,000 to $2,000 to $3,000, and we ask for submissions from the general public. Our newsletter goes out to, I think, like 30,000 viewers, and so the general public out there, we have researchers that are very dedicated to prior art search, submit their prior art. Our internal team reviews all of the various submissions and actually posts the winner and we post the winner for the public to see. We pay the researcher for winning, and that signals to the NPE, these patents might be invalid. It also provides art for everyone, not just members, to be able to file their own challenge if they're interested or use that in their own leverage for negotiations.
Can you help me understand what exactly the members I guess, getting? Like, can you explain how Unified Patents works in connection with the memberships? Do the members get to direct what cases you are interested in challenging, or how do you kind of proactively support and benefit the specific members?
Sure. So it's a glimpse of how Unified works. Every Friday morning, bright and early on the West Coast, we get together and review all of the NPE litigation that happened throughout the week. So we determine where our members sued, where our technology area is implicated, was a competitor of our members sued, and is this something that's going to be important? We also have a lot of knowledge about which law firms are traditionally bringing these cases. Are they usually file and settle kind of nuisance? Are they more sophisticated? Are they financed? Things that we can have a better assessment of all of these different campaigns that are happening within any given week. And recently there's been quite a significant number. So this Friday is going to be a busy one. We determine then, what do we do with each particular campaign? Do we plan to file? Do we reach out for a pre-filing settlement from this entity? Did they sue a member? Or do we think that this is something we can deter from our members? Or do we think that this campaign is purposely deterring activity from our members? And do we put it on patrol, like I mentioned? Do we find some prior art and put it out there for the world? And that is something that we are doing internally as a unified team. Because our members are members of zones, they are going to benefit from the activity that we're doing within those zones. There's definitely opportunities for our members to tell us what they think is important. Is there a patent within this 5 patent campaign that is more important, or is one of them a supplier issue? Are these things, are our members indemnifying something that they're not named on? These are all very important things that we're learning around the ecosystem. And we rely heavily on our knowledge about where we think these are important campaigns for us to challenge. And we make those decisions. And of course, considering the membership input. And we talk to our members all the time. So my team is talking to our members usually on a monthly cadence, sometimes more frequently. Everyone generally has my cell phone number. So if they hear a letter campaign or a patent assertion out there, they want to get some intel on, how big of a threat this might be. We have some of that knowledge and insights that we can share.
You mentioned in your last comment about a settlement. If Unified Patents decides to settle with an NP, what would a settlement look like to the benefit of the members?
Yeah, so this is the unified motto. We never pay NPEs. So that's a very, very easy answer. It's zero settlement, $0 settlements always. We want to disincentivize NPEs from settling for money and coming back to our members and coming back to the well for more settlement. That's the way we try to break the cycle. And the way that we get NPEs to settle with us is really the pure threat of filing a reexam. We have a very high, 90% success rate. So if we challenge a patent, we're likely to invalidate it. So the patent holder has a choice whether they settle with Unified and give a license to all of the members and basically have the freedom to go outside of the membership, or do they risk their patent being invalidated? And based on that credibility, we have successfully been able to negotiate licenses for our members. And if, for example, we're not able to negotiate a license, or it's an entity that is litigation finance, for example, we will go the distance and invalidate that patent and post prior art, everything that we can do to arm our members to be able to have a stronger position. The one thing too I want to mention, as a member, you get to keep that license for the life of the patent. So we have, members find a lot of value in this membership. They don't typically, retention is pretty high, but we don't leverage that by saying you can't get the licenses if you leave. You will keep the license for the life of the patent and not for the life of the membership, which I think members find to be very beneficial.
Yeah, I was just writing that down. Actually, didn't know that. So that's a great membership benefit. And also interesting to know that you're meeting with your members monthly and getting their input on things. And certainly 90% success rate is would be concerning to anyone who didn't want their patent to be invalidated. So what trends are you seeing in patent disputes and IP strategy? How does Unified Patent support these shifts for its members?
Sure. So it feels like a lot of things are up in the air a little bit these days. One trend that's been pretty steady is the Texas has been a favorite venue for NPs, Texas jurisdictions. Western District was for a long time the top jurisdiction at Judge Albright's court. It did shift in the last few years based on reassignments. So when you filed a case there, you actually, instead of being automatically in Judge Albright's court, you did get a bit cycled through. So that has now shifted for Eastern District. And that has pretty much over the last few years regained prominence and remains to be the significant NPE jurisdiction with pretty high verdict activity. So about 44% of all NPE litigation in 2025 was in the Eastern District. The other bigger trend that we're seeing is, I touched on a little bit, is litigation financing. So third party litigation funding that goes into NPE activity and acquisitions. We've seen some huge funded portfolios out there that are being asserted through both litigation as well as letter campaigns. They're big portfolios, they're big asks. Companies are always concerned about those and trying to find positioning and risk aversion tactics. We did see a massive capital influx in the space. And it's interesting because patent litigation tends to be uncorrelated to the market. So the more iffy the market feels, the more funding probably goes into patent litigation, with 20% of new funding allocated in 2025 going into patent litigation. And about 30% of all recent patent cases do have some sort of funding. Down economies also, based on my past transaction experience, tend to increase patent transactions. So operating companies with large portfolios, for example, are looking at ways to cut costs, and that might be monetizing some of their patent assets and cutting down on maintenance fees, for example. And those patent portfolios tend to go to NPEs and at a lower cost perhaps. And that, again, that arms them for more litigation. And then, of course, the IPRs. So the current administration has moved towards a more aggressive use of discretionary denials, meaning that it is a bit harder for petitioners to get the IPRs instituted. Even if you have strong invalidity arguments, there might be different factors that the administration is considering. So, for example, prior to the administration, institution rates were about high 60s. Over the last few months, they are about 22% institution rate. So takes away one of those post-grant challenge options that I outlined. Now we're moving towards re-exams, which seem to be a bit more favored, which is great for Unified. We've had a lot of experience and success in filing re-exams, but this unpredictability of whether to file and invest in IPRs and challenges has been keeping everybody, operating companies, a bit on their toes as to how to structure their defenses. So I think the combination of all those factors, funding, lack of access to IPR challenges, is going to probably increase NPE filing volumes and put a greater pressure on settlement for operating companies, which, unless they adopt a more kind of systematic deterrence and risk deterrence profile.
I know I'm probably about to get hit with a long list of abbreviations, but are there tools that you plan to expand, new tools that you plan to add, given some of these shifts in the intellectual property landscape that you just mentioned? I mean, what should members be looking forward to? And commence abbreviations.
Well, I actually, and we've moved from acronyms to gemstones. So Pearl is our invalidity claim charting tool. That is, I think, our coolest, newest, on the topic of AI development. It is available to our members on the Unified portal. Invalidity claim charting tool our software team, which is strong, small but mighty, developed it with and iterated it with our legal team, right? So we have a team that's all they do is file re-exams. They're claim charting all day, and they're feeding their feedback and improving the invalidity claim charting tool. So that has been a huge one. I was just talking to them today about ways we can market this more. We don't market it. We give it to our members as a free benefit tool. We do have our law firms that work with us using it as well. Our patrol contest researchers can use that invalidity claim charting tool. So that's been a really great one. We do have on our unified portal a lot of data and analytics. So we have these are a lot of acronyms. So the PVIX score, which is the portfolio value index, you can assess your portfolio based on various factors to see where the value might be in the portfolio versus the SAVIX, which is how much it's costing you to maintain that patent. And those are all going back to portfolio management tools. So you have a big portfolio, you can kind of at a glance see where your value sits. We have some very interesting velocity of innovation tool as well, which you are comparing yourself against your competitors to see where each of you are filing based on art unit and things like that that are giving you a better landscape. And then of course the SEP tools, which are constantly evolving and responding to the needs of our members. So one of our members suggested adding all of the video codec tools like HEVC, VVC, and standards to look at under one window, basically. And so our team is just developing those in response to how to our members to better utilize those teams. Other not traditional tools, but of course, we have our policy program under Unified Edge, and policy right now is a very important topic. It has been over the years. There are some proposed rule changes that are out there that impact tech companies. We participate in all of the discussions. Our general counsel just did a staff briefing to kind of inform the staff members about the trends in NPE litigation. We're filing amicus briefs. We actually aggregated all of the comments for the proposed rules to help better understand and discern where companies are seeing issues in those proposed rules. And according to the feedback that we get there, the office is actually considering those comments. So we'll see how those go.
I just wanted to circle back on something because it's just top of mind for me right now. The IPRs versus re-exams, I think it's very hot topic right now. As you mentioned, institution went from about 60% to 22% over the past several months. And I think also I've seen some charts that a lot less people are even trying for IPRs. So, it's probably also this law of small numbers. There's just, it might be 22%, but it's a smaller number of people even asking. But one of the things that I think is interesting that you said earlier is that Unified Patent switched really to re-exam focus prior to this change in IPRs, which is really fairly recent. What have you really seen as the benefits of doing a re-exam versus an IPR?
Sure. So one of the things, re-exams, we have seen a quicker grant rate. So IPRs take about 6 months to be instituted. We have seen about sometimes as quick as 4 weeks to be granted. So that's one thing, if you are challenging all the patents in a particular case, and those are granted, you can motion to stay the district court proceedings in light of the re-exam. That has been a tool that our members have used, and even outside of our membership. It is once you file a re-exam, as opposed to an IPR, which you can terminate pre-institution, post-institution, and so forth, re-exams you kind of start it and you don't have the ability to pull it back. That scares patent holders. So they don't have that, oh, well, let's see if it gets instituted and then we can talk settlement. It encourages them to settle pre-filing. And that has been a big benefit. Most of our licenses have now been pre-filing. Sometimes they're post-filing, which means we filed a re-exam on one patent in the campaign, and they didn't like the outcome of that, and then they will settle for the remainder. but that is one of, I think, the bigger benefits is that we have been able to negotiate pre-filing, which is also budgetarily allows us to take those resources and file more challenges. And so that I would say is the third benefit of the re-exam is that we're able to do more.
Yeah, that's huge. I mean, that seems really clever. I suppose you have to be very careful to make sure that you keep your 90%, stat by carefully reviewing what cases you do throw into to re-exam. Do you see pushback? Well, I mean, I suppose this is always true, but pushback when maybe you haven't. Do you show the NPEs, kind of what prior art you have, or do you just kind of say, I have a bucket over here and it could be terrible?
Yeah, yeah. We do. We do. We have it's a different level of leverage, right? Sometimes we just reach out. Sometimes we have to show prior art, a draft re-exam, and then sometimes if they're, not responsive, then we actually file it. So we definitely back up that threat of the filing. Absolutely. And sometimes, like I mentioned, you do have to show, hey, we're serious. We're going to invalidate one of those patents and then kind of strong arm them to settle for the remainder of that campaign.
All right. Well, so fascinating. Thanks, Sasha. I really feel like you guys have cracked it. So good job for helping all of the practicing companies out there try to break the cycle here. Really appreciate it.
Yeah, it's ever evolving, and it's great to bring in new members and to help support others in this fight against NPEs. Thank you so much for having me.
Thanks so much for listening to this episode of the Semi Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.